everybody. My name is Michael Sears, and we'd like to welcome all of you to our 30-minute Thursdays that we hold approximately every 2 weeks, where we talk about a financial topic that we think is of interest to most of you. And of course, our greatest desire is to make certain that you can take the ideas that we teach during these 30-minute Thursdays and you can go home and apply them in some way or another. So we're delighted to be with each of you today, and delighted also to have Seth with us today, who's a financial advisor in our firm. So welcome, Seth. We're glad to have you with us.
I'm glad to be here, Mike, and I'd like to welcome everyone who's joining us on the call today. Just a reminder, like always, if you'd like to comment or ask a question, please use the chat feature on your computer or your cell phone. We'll try to get to them as we can. It also helps us see who's joining us.
And so that brings us really to today. And if you notice today, we have a third person with us today. This is Seth Morris. He's an attorney with the firm Olson & Hogan, and he has been so gracious to join us today and to speak to us about one of our favorite topics, which is estate planning. So welcome, Seth. We're just delighted to have you with us today.
Oh, I appreciate that introduction. Mike, Seth, I'm glad to be here.
So I'm thinking about all of our listeners, Seth, and I'm thinking maybe we just start with the basics today, and let's just begin with, really what is estate planning, and why do you think it's important? Why don't we start there today?
Well, I think estate planning in its simplest terms is your plan to provide for yourself, your loved ones, and your estate, both during your life and after your life. It's the plan of what happens to all of those different factors, and who's going to make decisions, and who's going to step into your shoes, so to speak, and manage things when you're gone or no longer able to act for yourself. Your estate, just to define that, consists of everything you own. So that's your cars, your bank accounts, your home, the ring you got from your great-grandmother, everything that you've amassed during your life. And your estate plan is your plan for all of those things and how they benefit your loved ones. I don't know, does that sound like a pretty good definition of estate planning, Mike?
I like it a lot. What do you think, Seth?
I think that sounds great. And another thing, Chase, when we think of estate planning, or I think when a lot of people hear estate planning, we think, okay, yeah, that's for these wealthy people or these people who have a large estate, or maybe in their retirement years or ending or nearing the end of their life. What can you comment on that?
I think that is a very common misconception, Seth. Wealth management and administration is one aspect of estate planning. But the size of your estate really has nothing to do with how important it is for you as an individual to plan for your estate and your future. In fact, estate planning can be more critical for those with a modest estate because they have less to lose over the long run or in the future. But when I think about estate planning for myself and my own family, that's really the last thing I think about. The money, the things, right? I think about my kids, my two daughters. I think, what's going to happen to them if something were to happen to my wife or me tomorrow? Who's going to take care of them? Who's going to help my wife? How easy are things going to be for my wife? Or what happens if, heaven forbid, I'm in an accident and I can't work anymore? And who's going to make those healthcare decisions for me? Who's going to take care of us? So as you can kind of see, the wealth, right, and what's going to happen to my things, that's a little bit further down the list. I care about who's going to take care of my family and how all of my estate is going to be used for their benefit or my benefit during my life.
So maybe that's a good segue into, if you can see the board here, everyone, maybe we can build the rest of our time together around what we call the 6 key estate planning documents. Does that sound okay, Seth?
Yeah, absolutely.
and you can see that those 6 key estate planning documents, and not necessarily in any special order really, but wills, we talk about that as an estate planning document. We talk about revocable trust. There's all different types of trust, but I think today, keeping things basic, we're talking about family trust. You hear that term, or revocable trusts. About power of attorney. There's lots of different types of power of attorney, but I think we're homing in on financial power of attorney or healthcare power of attorney, maybe those two. And then, of course, maybe you don't think about this, but how many of you, when you had maybe you had an IRA or you had a life insurance contract, and of course, with all of those types of financial documents, you had to list a beneficiary. And so a beneficiary designation is also a key part of our estate plan, because a lot of our assets won't necessarily pass by way of a will or by way of trust, but will go with by way of what our beneficiary designation is stated. And then finally is, do we even know what all the assets look like? And of course, Seth, I think it would be fair to say, from a financial planning point of view, what can you tell me about an asset list? I mean, what do we do in our firm that's very helpful as a beginning step, maybe?
Yeah, we'll kind of jump to the end there on asset list. So as many of our clients are aware, we create a map for them that it has a specific, we call them legs, a specific leg for every asset that they own. That's one of the first things we go over when people come in, is we want to identify what assets they have, because we want to know how they work together. But an asset list is also very key in your estate planning, so that whoever comes in to take over or help when they need to, they know what they're looking at and what they're looking for.
So that's probably very helpful to you, Chase. Is that true, that when someone comes to start working on these estate planning documents, is it for you a beginning step as to what do the assets look like, and then what are their goals for the future? Am I saying that right or no?
Absolutely. And I wish all of my clients who came in had one of those lists that you're talking about. That can be one of the most difficult things to start off, just identifying what we're dealing with, right? So that we can diagnose what we need to make plans for, and then treat that by putting into place these contingencies for each of those different legs that you talked about, Seth. So an asset list is not only essential for helping your attorney identify what he needs to do in creating a plan for you, but it's going to be a huge tool for your heirs, your spouse, your kids. When you're no longer around, they have a list that's showing them exactly what they need to work with and what they need to do. I wish all of my clients brought one of those lists in. To answer your question, Mike.
So Chase, there's a question by one of our viewers that says, "What is considered an asset?" You want to share that with us?
So generally speaking, these are going to be items of monetary value, but they're going to be items of personal property, like your car. They're going to be titled assets, so things like your home. They're going to be bank accounts, investment accounts, retirement accounts, anything that we can assign a monetary value to. There's also this, other value behind some of our assets maybe we don't think about, and that is, the emotional attachment that we have to certain items that may have very little monetary value, but they're worth the world to us, right? And sometimes those are the most important things in our estate plans, making sure that grandma's ring goes to your daughter, right? Hopefully that answers your question. It's kind of a broad term that we're using or kicking around here when we say assets.
And of course, that's I think it's important, because how many times do we think, really as financial advisors, we think we have a list of all of the various financial assets that a person has, only to find out later we don't have them all. They're not all listed. And of course, when we're talking about leaving assets to the next generation, it would sure be nice to have it all in one place. We know exactly where it is, not to find out later that, oh, gee, here's some investments that we don't even have a named beneficiary to, etc. Right? So I think this is really key of having that.
Right. So Mike, do you want to work through this list then here?
Why don't we talk with the importance of what is a will, what does it do, and why is it important, and then we'll work on what is the difference between, I think the distinction between what is a will and what is a trust.
All right, absolutely. Well, everyone's heard of the infamous wills, right? And wills still are the standard document in most estate plans. And that's going to be across all the states here and even on an international basis. Your will, in essence, will name an executor or personal representative, a person, so to speak, who is going to step in and administer the distribution or transfer of everything identified in the will. Now, things that are subject to distribution or to be transferred by a will is everything that you own in your name as an individual. And that's going to be important when we're talking about trusts and probate a little later on, maybe. Another really huge aspect, and I think the most important part of the will, is the ability to name a guardian for your children. Okay, that's going to be absolutely huge for those of you who have little kids or dependents or people who need ongoing long-term care. You have the ability to name your priority list on who you want to step in and be mom or dad when both you and your spouse pass away. And maybe I'm getting ahead of myself here, but it's vital to have a will that meets all the formal and execution requirements for the state in which you live or that you reside in when you pass away. So that's going to require you to maybe be checking your will throughout your life because you're going to move, right? Things are going to change in your life. And maybe the guardian that you wanted 5 years ago is no longer the guardian that you want for your kids now. So this is a living document. You need to treat it that way. At least, hopefully that answers that question on what a will is, Mike.
So, Chase, so I'm a young, father. I have 2 kids at home. If I had, let's say I've gone to my brother or my neighbor and I said, hey, I want you to watch after my kids if anything were to happen to me and my spouse, but I never put it in a will. That doesn't suffice. If me and my wife passed away tomorrow, he can't come and say, well, Seth said he wanted me to take care of his kids.
Yeah, that's going to be a sad situation for your kids. You're going to be looking down, wishing that you had put it in your will. So what would happen in that situation is there's going to be this need for a judge to get involved and determine who he thinks or she thinks is the best person to take care of your kids. Simply telling your neighbor that, hey, I want you to take care of my kids if I pass away, that's not going to cut the mustard, okay? You need to have a will or a formal document, right, that meets all these formal requirements under state law that designates who you want to step into that role. And oftentimes, it's not going to simply be one person necessarily. You can have co-guardians, right? You can have a guardian that only has authority to take care of the kids' day-to-day needs, right? To make those decisions about education and going to summer camp. And then you could have a conservator, so to speak, or a guardian that managed the finances for your kids as well. You can name that person in that instrument. But Seth, you definitely need to name your neighbor in your will if that's the person that you want to take care of your kids. And I would suggest having a backup plan, right? Because we don't know what's going to happen to your neighbor in a month or a year from now.
So I think so. Go ahead, Seth.
I'm just agreeing with him. You can go ahead, Mike.
So we know what a will is. If I'm married, oftentimes I may leave everything to my spouse and vice versa. and those are for assets that are in our own given name, right?
Mhm.
So when does a person step up from with a will? They might consider a trust, or I think in many cases we see, at least what I see is that almost you would see a person that would have a will and then also a trust, because assets can pass to the next person by way of will. So where does the trust fit into this, Chase?
So you bring up a very good issue here. So the will is going to primarily deal with those assets that are non-titled, right? So things that you don't have a deed to, or there's no account name on that asset. Now the trust becomes really the centerpiece of any estate plan, because unlike the will, which typically just tells us where things should go, the trust actually owns or holds your property. So your titled assets, and you can title your home in the name of the trustee, yourself and your wife, of that trust, that family trust. And then when you pass away, everything that is held in that trust, okay, or owned by that trust or the trustee, could continue to be managed and administered according to the terms that you lay out in your trust instrument. Okay. And what's really important about the trust is that when you have only a will, okay, we still need a judge to come into the picture and read the will essentially and say, okay, seems like he wants this to go there, and we want this to happen to the home. With the trust, we don't need a judge for anything, okay? So the trustee, the person that you leave behind to manage the trust after you pass away or you become incapacitated, can continue to administer it just as if you were there. He steps into your shoes in a very real and meaningful way. And so administering your assets when you pass away or become incapacitated is so much easier when you have a trust. Okay? The other, big thing that you brought up, Mike, is that in a lot of states, you're going to have different laws that dictate how property is owned or held by husband and wife or individuals. So you have these community property states and these separate property states like Utah. California, for instance, is a community property state. And those are going to have huge implications on your estate plan. And your estate plan needs to address those. Now, if you have a trust, it is so much easier to deal with the nuances of different state laws because you can move around during your life. And one of the easiest things that the trust does is allows you to title all your property in the name of Mr. and Mrs. Smith, trustees of the Smith Family Trust. And they don't have to worry necessarily or as much about those nuances of state law.
So if I understood what you had said is that if I have a trust and the assets that I put in the trust are in there, because I would imagine every once in a while you'll meet someone, Chase, who sets up a trust and thinks, hey, I'm done, only to find out that the assets that were supposed to be put in the trust never were put in the trust. Does that happen?
Yeah, I think it's the same guy who tells his neighbor to take care of his kids after he's gone, right? No, well, so what's important to remember here, right, is that even though you got this new fancy trust that has all the bells and whistles and, you spent a lot of time and effort working with an attorney to develop it, if you do not assign your assets to the trust, they are not funded or held by the trust. And what's important to do here, the reason we have trust to begin with, is so that your assets are no longer in your name, right, or subject to probate. Because if they were in your name or owned by you as an individual, then you need to have provisions in your will to address it, and then the court will get involved. If they are held in your name as trustee of a trust or held by the trust, we avoid any court involvement, and it will continue to be administered according to the terms of your trust, but only if it's been titled there, right?
And would the exception to what you just said be that if I have an IRA, if I have a retirement plan, if I have a financial document that has a named beneficiary, I have a beneficiary designation, isn't it true that I can avoid probate with that? Because a beneficiary designation will avoid probate. And so that is another way to pass assets. You talked about passing assets to the next generation with a trust without probate, but a beneficiary designation will also pass assets to a person without probate. Is that a true statement, Chase?
Absolutely. Not only is that an alternative method of avoiding probate, but it's an essential part of your estate planning process and something that you need to be continually checking throughout the course of your life to make sure that the beneficiaries on your accounts, like your IRAs or your non-qualified accounts, are designating the appropriate living beneficiaries, right? And there will be some items or some accounts that we won't assign to the trust. And so it is vital that you need to have those beneficiaries up to date at all times. And, we work closely with financial advisors when we're checking that to make sure that everything is in order. I'm sure that's something that you do on a regular basis, right, Mike and Seth?
Yeah. Mm-hmm. Yeah, I think too, just really quick, touching on beneficiary designations and, how that might work with trusts is one of the things that we see is we have a young couple, maybe they have kids, they don't even own a home or they don't have substantial assets. And they think, why do I need a trust? But one of the things one of the ways a trust can play nicely in their estate plan is if they do have minor children. Obviously I would name my spouse as my primary beneficiary on a life insurance policy, right, Mike?
Yeah.
But if I don't want to name my minor children as the contingent beneficiary, because I want them to be able to use that money or access it without court intervention or petitioning the court for those funds, you would want to name your trust as the contingent beneficiary. And then the trustee or the guardian can access those funds. Is that right, Chase?
I think that's absolutely correct, Seth. So, yeah, a lot of times we'll set up these life insurance trusts, right? And there could be any number of different trusts that you create to continue on well after your life and providing for your kids. That's one advantage over a will, right? So perhaps you don't want everything to go to your children when they turn 18 or 21, right? And we need to set up some type of trust that continues to manage and administer those funds and, distribute it on a different schedule. I know that personally, if I had gotten, a lot of money when I was 18, inherited that way have made a huge difference in the trajectory of my life, right? But yeah, it was a great point, Sal.
So there's a question that says, another question says, can we put our 401k in the trust? And the answer is not normally would we do that. And the reason that we wouldn't, because number one, we have a named beneficiary, and beyond the scope of today, there are some tax advantages if we would have a named beneficiary on a retirement account. With the way the new laws have changed, if we name a named beneficiary, we've got 10 years. Of course, if we have a non-spouse beneficiary, we have 10 years to deplete that retirement account, as opposed to if we were to just fund that, if we leave the trust as the primary beneficiary, we could run into some tax implications on that. So normally we don't see retirement accounts where the beneficiary is the trust. Normally it's a named beneficiary. By the way, we're now coming up on about 5 minutes left. We got a couple of other things we want to hit for a second. Can you briefly share with us, Chase, why a power of attorney would be so important to a person? So, for example, think about, let's see, Julie and I, we both have power of attorney for each other. Why would that be important to us? And that would be the same for anyone else. Why would that be important?
So, Mike, if something were to happen to you tomorrow and, heaven forbid, you were in a situation where you could no longer make decisions for yourself, sign documents, your life is going to continue whether or not you disagree or want it to be put on pause, right? It's going to continue on, and decisions need to be made, things need to be done. Power of attorney is a huge tool that allows, in this case, your wife, right, to step in and make decisions for you, both about, maybe your private life, your health care, financial decisions, maybe even about your business to some degree. I'm sure you probably have some pretty, expansive controls and restrictions on that. But, in that sense, it's really important to have a power of attorney that allows life to continue on and decisions to be made. And that power of attorney instrument will empower a trusted individual to become your agent, to make decisions when you can't make them for yourselves, okay? And I know we hate to think about that. And unfortunately, by the time a power of attorney is needed, if you don't have one, it's too late. Then we need to go to a court. We need to have a judge decide who's going to take control, right? Who's going to make the decisions about your long-term health or whether or not we pull the plug on you. Sorry to be morbid, but in a very real sense, this is why it becomes so important.
And this person that we name should be the most trusted person that you could ever think of, because you're giving authority to that person to make decisions for you and your behalf, both financially and maybe from a healthcare perspective. So we certainly want to keep that in mind.
Absolutely. And they could be different people, Mike, right? So I'm sure that your wife is power of attorney, and that's the same for me. She has power of attorney to make those decisions about my health care, right? And those, medical decisions and other decisions as well. But they're not necessarily going to be the best person to make legal decisions or financial decisions, especially when it comes to my practice, right? Someone else probably is going to be a little bit better suited to fill that role. And so you can have different powers of attorneys, and you can dictate the scope, when those power of attorneys kick in, and really how much power and the types of decisions that those individuals can make when you can't make them.
Okay. But here's maybe a closing question. So Chase, so suppose for a second I have a will, I have trust, I have a power of attorney documents, and I set up these documents 5, 6, 7 years ago. Is it important to? Do I have to just do this one time, or should this be something that should be looked at with some regularity, I suppose, because things change? What are your thoughts, real quick?
Absolutely. And I schedule times or follow-up times in, a couple of years, few years. And anytime you've had a major life, change in marriage, death in the family, you change states, change occupations, you should go visit with your estate planning attorney and make sure everything's up to date.
Okay. Love it.
I just appreciated the opportunity to come on and talk about something that I really enjoy, and it's an important part of my practice. And good luck to all you who are listening.
And with that, our time is up. Have a wonderful week, everyone. Thank you for joining us. Until next time, we say, have a wonderful day. Take care.